We will go on the record in the matter 25 CF 80, State of Wisconsin versus Shane Cook. This state appears through Assistant District Attorney Jose Vila in person. We have Nicholas White, Defense Counsel in person, along with Mr. Cook. We're set here today for a plea and sentencing. Mr. White, please update the court.
Your Honor, Mr. Cook was able to get an AODA. He completed that, and that satisfied the terms of this offer to amend count 1 to a misdemeanor possession of amphetamine. The agreement is to dismiss and read in counts 2 and 3 for a joint recommendation, cost and final only.
Okay,
I have a plea questionnaire for you.
thank you. Thank you. And Mr. Cook, I do have to remind you that you are behind on your attorney's fees. Yes.
I can't, I didn't bring my hearing aid today.
Do you need a set, a hearing device?
Yeah, that way I can actually hear you.
Okay.
I forgot my hearing aid, so. I did talk to out here. She's gonna put a thing into my boss to make sure it keeps coming out, so I'll get caught up.
Excellent. Good. I'm glad to hear that. Thank you.
Put that by the microphone.
Thank you.
One more thing.
All right, let me know. Can you hear me? Can you hear better, Mr. Cook?
Yes, ma'am.
Excellent. Okay, so you're going to take care of the attorney's fees. You're going to make sure that it's taken out of your check. That's great. Thank you. Okay, so I have heard the basis for the motion or basis for the agreement that's been reached. I need a motion to amend count 1 from methamphetamine to amphetamine.
So made.
Granted. Okay, Mr. Cook, I have in front of me the plea questionnaire waiver of rights form. Do you recognize that document?
Yes, ma'am.
Is that the document in front of you?
Yes, ma'am.
And did your attorney go over this document with you thoroughly,
Yes,
word for word?
yes,
Is that your signature?
yes,
You are pleading guilty to 1 count of possession of amphetamine. You're 45, you have 12 years of schooling, you can read, write, you understand the English language. Your attorney went over what the state would have to prove your guilt beyond a reasonable doubt and the maximum possible penalties, no mental illnesses or disorders, all correct?
correct.
You do take a medication. Are you okay?
Yeah.
That was loud, so I heard oh from the contact. Okay, so you do take a medication. Is it a medication that would interfere with your ability to comprehend or to understand things?
No, it's just for my asthma, plaque psoriasis, and acid reflux. That's it.
Okay, good. So nothing that'll interfere. That's great. Okay, so because you're charged with crimes, you're entitled to constitutional rights, and each of those rights is listed on that first page of the plea questionnaire. You're nodding your head up and down that you know that. Did your attorney thoroughly go over those rights
Yes,
and you understand them completely?
yes,
Do you need me to go over those rights with you in any more detail?
no, ma'am.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, ma'am.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, ma'am.
Do you understand here the state would have to prove on or around May 24th, 2025 in Burnett County, Wisconsin, you possessed a substance. The substance was a controlled substance in an amphetamine classification, and you knew or believed that substance was a controlled substance in an amphetamine classification. Do you understand what the state would have to prove?
Yes, ma'am.
Do you understand the maximum possible penalty upon conviction could be a fine of up to $5,000 or 1 year of incarceration or both.
Yes, ma'am.
Do you also understand that there is an agreement here for costs only? But do you understand I'm not bound to follow that recommendation?
Yes, ma'am.
I could sentence you all the way to that maximum possible penalty if I thought it was warranted. Do you understand?
Yes, ma'am.
Do you still wish to proceed and enter a guilty plea?
Yes, ma'am.
Did you go over the criminal complaint with your attorney?
Yes, ma'am.
And in particular, that section called the probable cause section, where it says what happened and why you were charged with the crimes?
Yes, ma'am.
You're smiling and nodding your head up and down, so you understand.
Yes, ma'am.
Okay, and for the most part, are those facts accurate?
Yes.
Are you pleading guilty to possession of methamphetamine or amphetamine because you are guilty?
That's a tricky
Talk to
question.
your attorney before you answer. Brief moment to discuss with counsel. All right, and so you had an opportunity to discuss what that means and the facts and all of the things with this plea with your attorney?
Yes, ma'am.
Okay, so are you pleading guilty to possession of amphetamine because you are guilty?
Yes, ma'am.
Okay. Mr. White, may the court use the probable cause section of the criminal complaint along with the statements made by your client to find a factual basis?
Yes, you may, Your Honor. We stipulate.
Has anyone made any threats or any promises to you, Mr. Cook, for you to plead guilty?
No, ma'am.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, ma'am.
and voluntarily?
Yes, ma'am.
Has your attorney represented you competently?
Yes, ma'am.
Has he answered all of your questions?
Yes, ma'am.
Has he looked at this matter thoroughly?
Oh, yeah.
And you're satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
No, ma'am.
As to amended count 1, possession of amphetamine, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the amended count 1. Count 2 and 3 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Before I ask for arguments, Mr. Cook, have you gotten your driver's license yet?
No, ma'am. I'm working
Where
on
are
that.
you in that process?
All I got to do is get enough time to go over and take my test. That's it.
Please do that.
Yes, ma'am.
Because I don't want to see you in front of me for an OAR again.
Okay.
All right. Okay, so Mr. Vila, argument?
Thank you, Your Honor. I would ask the court to adopt the joint recommendation. The crux of this case is that this was a personal use case. Mr. Cook didn't harm anyone. He wasn't dealing to the community. I think he realizes that he needed to get some kind of treatment. He did that on his own accord. As such, I would ask the court to continue to incentivize folks to seek out treatment so that they can continue on their path towards sobriety. As such, I would ask the court to adopt the joint recommendation for costs as being appropriate. Thank you.
Mr. White?
Thank you, Your Honor. I agree with the prosecutor's summary of this case. It appears to have started with a wellness check of Mr. Cook as he was in his vehicle and as he was exiting the vehicle. The item was found and tested. We've discussed some of the same things that's been brought up today, like his driver's license. That's something he's working on. I'm not sure if an AODA was necessary for that, but he has done one. So I think he's working towards that. We'd ask for this just to be a cost and fine only resolution because Mr. Cook, even though he didn't qualify for a public defender in this case, he does have some financial issues, and by resolving as a misdemeanor, he keeps his housing. He knows he has to work on his driver's license, and he's made that effort to appear in court. The AODA that he did from February 5th actually was done on February 2nd with Jessica Cowder, and I have a letter here from Sue Wheeler, the administrative specialist. From my understanding, Mr. Cook does have a follow-up meeting. It's just something he needs to follow through on. So that's all to his own benefit. I'd ask you to go along with our agreement.
Thank you. Mr. Cook?
Yep, the 28th, I haven't, she called me back and was asking, there's a couple of questions on there. She said it doesn't have nothing to do with this, but that she would like to talk to me about. So I said, okay, she needs to get back to me with the cost. And then I'll be set up on the 28th, I believe.
Excellent. Anything else you want me to know or you want me to consider?
Well, just thank you. That's all.
Thank you,
You've been really polite with.
Mr. Cook. I don't know you well, but I know you pretty okay-ish, pretty well, from the times you've been here in court. I want to say you are a nice guy. You do what you need to do. You've even walked from Webster to get to court.
I get
because
caught
you-
up like everybody else. Sorry, I mean,
What?
like anybody else, I get caught up with, somebody that I shouldn't have been with and end up getting what I got now. And I'm not, that's how far as I'm leaving it. That's, so I just gotta make a better judge of who I keep around, I think.
I'm really glad to hear you say that because I do think you're smart and I think that you do put in the effort. I think, aren't you on disability or something?
No, I
Okay.
could have been, but I
That's
chose
what it
not to
was.
be. I can still work, so I don't see any reason why I cannot just work instead of getting disability.
That's what it was. And I respect that a lot. I really, truly do. So you do want to work, you do want to be responsible, you do want to take care of things. You're following through with your treatment. You're going to be following through with getting your license. When you can't get to court, I'm going to be watching. And so you have actually walked a very long distance to come to
I
court.
even called the cops one time to make sure I got here.
And because and I like that because that shows me that you respect the court and you respect my authority.
Well, I do expect the law. I respect the law. I actually really do. It's just sometimes that's all I can say. Sometimes stuff happens and
I really hope you are going to be making better choices about your associates and their character and what they do, because all they're going to do, the
Yep.
negative ones are going to bring you down.
yep, even if I don't know what they do and I just need to be like the sheriff told me, you just
Pause for a second. This is a fascinating courtroom moment. The judge isn't just handing down a sentence, she's reading the defendant's character. Notice how she balances accountability with encouragement. In many misdemeanor drug possession cases, courts look for signs of responsibility, treatment, honesty, and effort. Cook, walking miles to court and completing an evaluation? That signals rehabilitation. But here's the big question. Will this second chance actually stick?
you'd be like, hey, what do you got on you? What is this? Where you going? If you don't, then just say, hey, I'll just walk. So and he's right. And like Dave had said the same thing, just walk away. Stop it before it starts.
I'm really glad to hear that because I don't take you for someone who would be using methamphetamine or those
I
substances.
was being stupid.
Don't do it again.
Oh, no, trust me, I won't.
Continue to take control of your life. I think that the agreement is appropriate. You're addressing what you need to address. You're going to continue to complete the things that you need to complete, even outside of this case. So I find that that goes a long way for the court. You're not a safety risk to the public. And you have a good character. So the court is going to follow the joint recommendation. I'm going to assess $443 in fines and fees. You do have 250 down, so you don't have to pay a lot, but that can be taken out in addition to your attorney's fees, and it can be in a reasonable amount that you can afford.
Okay,
So it can be taken out of your check. So I am ordering that you provide your DNA to the jail. If they need it, they'll take it. If they don't, they'll send you on your way. So when you're done here, you're going to go to the day reporting for jail and see if they need your DNA.
okay,
You have the right to have it request it be expunged through a written letter to the Department of Justice, not to this court, but to the Wisconsin Department of Justice. It's easy to do. You can Google it or you can ask Mr. White. He can assist you. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I'm going to leave the monthly fee to I think it's at $50 a month right now. So even combining the court costs, the remaining court costs and fees with any attorney's bills, we'll just keep it at $50 a month until paid off in full.
Okay.
If you fail to make a payment or you fail to pay it off, not only will the court enter a civil judgment against you because you're always going to owe it, but I will issue a warrant and you can sit up to 6 months in jail.
Oh,
Very
no.
important.
I will
Very
pay
important.
it.
I do believe that you will be making those payments. I think that covers everything. Mr. Vila,
I believe so, Your Honor.
Mr. White.
I think that was it.
All right, good luck, Mr. Cook.
Thank you, Judge.
Good to see you. We will go on the record in the matter 25 CF 171, State of Wisconsin versus Daryl Moose. The state appears through Assistant District Attorney Jose Vila in person. Mr. Moose doesn't appear. His counsel, James McLaughlin, appears in person. Off the record, the court was updated that Mr. Moose posted bail, although it's not yet sent to the court for the court's processing, but he was able to post. He is not on the jail roster. And so therefore we cannot proceed with a preliminary hearing. So Mr. Vila, what is the state requesting?
I would ask for a warrant, Your Honor.
Any further statement you'd like to make, Mr. McLaughlin, or stand mute?
I would only argue as his advocate, Your Honor, that Mr. Moose, there has not been official proof of receipt of the bond posted. So there theoretically, he might be in custody in a different jail, although highly unlikely. And I did let the court know that I attempted to make residential contact, but his local phone is inoperable. The only thing I could say on his behalf, if the court feels inclined to issue a warrant to give a stay for me to try to make arrangements for a voluntary appearance.
Unfortunately, I don't do that. So no stay would be granted. I have looked at the Burnett County jail roster, confirmed it myself. I have also looked at Vine. He is not in custody anywhere I can see. So he fails to appear. We just had his hearing not too long ago. So he had actual and oral notice of today's date and time, and he fails to appear. Therefore, the court will issue a warrant. And for the record, he does have a history of failing to appear. So the court will issue a warrant.
Is there a sum for which he can then add as an additional surety to obtain release, or would it be a body only? I'll let the court rule on that issue.
I rarely do body onlys because I
Okay.
want people to have the ability to be able to post if they can. Unless it's a serious case. This is serious, but it's not in the sense of the seriousness of other.
Community threat.
Correct. So the court will issue a warrant, an additional $250 to be posted. I'm not going to increase the $250. I do know that he has financial difficulties. However, I am forfeiting the cash previously posted pursuant to 969.13 of the Wisconsin statutes. I may set it aside upon verifiable information that it was not out of his control, or he was unable to appear by his own means for today's purposes.
The court read my mind. I'd ask if there is exigent circumstances that defense can later show. I'd ask the court to allow that possibility.
That is permitted.
Thank you, Your Honor.
Thank you. We are adjourned. Well, you didn't get to see that one, but you got to see another one.
You have such bright young public defenders coming over, Your Honor. They
do.
decided to send the old incompetent one over, so you see the contrast.
Can I get permission to appear by his prelims by video?
Yes.
I mean,
Yeah.
this is probably the 5th or 6th time I've come over for prelims for him that he doesn't show up for on all this.
I am totally fine with that. I also go live.
Okay,
So you can just log into court live and you can watch it at that time.
okay,
Otherwise, I'm okay if you appear by video, but you have to make sure your name pops up press.
that's fine. I covered 10 counties. Like, I'm not in Burnett County. so
Yes,
I'm
I know.
driving.
Yes,
so,
I'm totally fine with that.
Okay.
But, and if you want the Zoom information, call my assistant. She'll be able to give that to you. But again, when you try to pop in, make sure it says press
Okay, perfect.
or whatever you are, the leader or whatever you
Yeah.
are.
Perfect, thanks.
My opinion doesn't typically matter, but I have no objection to that, Your Honor.
Okay, thank you.
I wish you all a good day.
Have a
Ms.
good day.
Capistrant. Let me just see if this is Mr. Chavaria. Is this Mr. Chavaria? I just let into the courtroom. The Samsung, you're muted. I'm asking you to unmute and start your video. I don't know.
Can you hear me?
Yes, is this Mr. Chavarria?
Yes, ma'am. Yes, Judge Mogen.
Okay, we'll get to you in just 1 second, okay?
Okay, thank you.
We will go on the record in the matter 26 CM 24, State of Wisconsin versus Cody Capistrant. The state appears through Assistant District Attorney Jose Vila in person. Ms. Capistrant appears in person with counsel Amber Sherwood. We're set here today in this matter for an initial appearance. At the last hearing, there was some discussion of giving information and having perhaps an amendment to an ordinance or something else. Ms. Sherwood, please update the court.
Yes, Your Honor, I spoke with ADA Vila this morning. I do believe that this matter is going to be dismissed in its entirety.
Excellent. So formal motion to dismiss,
So made, Your Honor.
granted. It is now dismissed.
Thank you.
So Ms. Capistrant, just make sure that you continue to talk with the Department of Health and Human Services and all of those things, and you're good to go, okay? Are you okay?
She's had a very hard couple of weeks, Your Honor.
I bet she has. Okay, Ms. Capistrant, if you want to wait just a little bit, Ms. Sherwood can be done in a second. I just have to go over another case with her, okay? So if you want to go have a seat in the back, or you can sit outside, whatever you prefer. We will go on the record in the matter 26 CF 07, State of Wisconsin versus Jose Chavarria. The state appears through Assistant District Attorney Jose Vila in person. Ms. Amber Sherwood appears in person, and Mr. Chavarria appears by video conferencing with late approval of the court, but apparently he was unable to get a ride. This is set for a preliminary hearing, but the court granted that due to the fact that Ms. Sherwood said that this would be a waiver of a preliminary hearing. Is that correct?
That is, Your Honor. I do have a waiver of preliminary hearing form. I was not able to get Mr. Chavarria to sign it as he was not here. I have read it to him. Would you like me to approach with this?
Yes. Did you read it verbatim?
I did read it verbatim, Your Honor.
Excellent. Thank you. Mr. Chavarria, I have in front of me the waiver of preliminary hearing form. It's not signed by you, but do you acknowledge that your attorney thoroughly read this to you word for word?
Yeah, yes, Judge Mogen. Yes.
And you understand everything on that document?
Yep.
And you understand the state has the burden to prove a felony was probably committed and probably committed by you?
Yeah.
And do you understand that by waiving your right to a preliminary hearing, you are agreeing that the state can meet that burden?
Yes.
You understand that once you give up your right to a preliminary hearing, it's forever and you cannot get it back?
Yes. Yeah, I understand that.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yep.
I will find that you are freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I find probable cause and I will bind the matter over. Information, Mr. Vila?
Thank you, Your Honor. I've gone through and filed the information. It mirrors the criminal complaint.
All right, proceed with an arraignment or set for another date.
We're asking for another date, so Attorney Reed may be present, Your Honor.
All right, then I'm not going that far out.
Cool. Cool.
March 6th at 9:30.
And just like that, the tone of the courtroom shifts. In the previous case, the defendant showed up and earned some judicial sympathy. But here, another defendant fails to appear, again. In criminal procedure, missing court is a huge red flag. Judges see it as disrespect for the process, and it often leads to warrants, higher bail, and tougher consequences. The lesson is simple. In court, showing up can change everything.
That would work for the defense, Your Honor.
All right, March 6th at 9:30, March 6th at 9:30. It's an arraignment. If Mr. Chavarria wishes to appear by video conferencing, he may. If not, he can be here in person, okay?
Thank you, Your Honor.
All right, thank you. We will see you then. We are adjourned.
Thank you, Your Honor.
Did you get those documents?
Yes, I went back and Mary pointed me straight to them.
Excellent. Thank you so much.
Your
I am
Honor.
feeling much better. Thank you so
You
much.
definitely look at last week, we were like, is Mogen gonna be okay?
No, I was not.
We were getting updates. You just had Attorney Hanu being like, guys,
We do not have him ever anywhere. All right, but thankfully we were able to log in. We will go on the record in the matter 25 CM 111, State of Wisconsin versus Matthew Richards. The state appears through District Attorney Kevin Schmidt in person. We have Adam Benson, Defense Counsel in person. Mr. Richards fails to appear. This matter was set for 9:30. It is now 9:36 and no appearance by Mr. Richards. He was not in court on January 21st, 2026, when the court issued a warrant for $250. He did post and bail himself out. He was provided today's date and time. He now fails to appear. We have no updated information. Weather is good, sunny and beautiful. What is the state requesting?
I'd ask for a warrant unless if Mr. Benson knows of something.
Mr. Benson, do you wish to make a statement or stand mute?
I will stand mute, Your Honor.
All right. He was supposed to do things with Mr. Hatch, and that was supposed to go into the offer. We do not have anything. Again, he is not here. You are court appointed, Mr. Benson. What the court is going to do is I'm going to issue another warrant. $500 cash, only judge may quash or posting of the cash. What I'm going to do at this moment, Mr. Benson, is I can either discharge you, and if he comes back after a decent amount of time, reinstate you if you wish. I can leave that up to you, but I can leave you in the case, and I'll leave you in the case for a week to see if you hear from him, to see if there is a reason why he's not able to come or to be here. I am forfeiting cash pursuant to 969.13 of the Wisconsin statutes. However, I am going to state on the record, it first must go towards paying Mr. Benson's bill and any outstanding fines and fees before it goes into the general fund.
And Your Honor, I did submit an interim bill after his last non-appearance on January 21st. If the court wants to give it a week and then discharge me and pay the bill, that would be terrific. So maybe you have already, I have no idea. So.
I am not sure, but thank you. I really appreciate those interim bills. And so I will keep you on full services for a week to see if we can figure things out. You should be paid this amount. We have his initial retainer but it doesn't quite cover it, but with this forfeited amount, it will cover it. You can bill for this time and any other time you've expended on this matter. If he shows up on the warrant, I will have Mary reach out to see if you wish to be reappointed.
All right, thank you.
All right, thank you. We are adjourned. We will go on the record in the matter 25 FO 342, Village of Siren versus Trenton Forsberg. The state appears, or the village appears through attorney Adam Benson in person. Mr. Forsberg appears in person without counsel. We're set here today in this matter for a court trial. However, the parties have been able to discuss the matter and have it worked out. Is that correct, Mr. Benson?
That is correct, Your Honor.
And what is the agreement that's been reached?
Mr. Forsberg will plead no contest to the citation and will pay a fee-only forfeiture of $114.50. 30 days to pay, and he says he can pay today.
All right, and that's all accurate and true?
Correct.
All right, so then how you wish to enter a no contest plea?
Correct.
The court will enter no contest plea on your behalf here today. I will accept the lowest amount of court costs and fees, $114.50. You're resolving it today. You're being responsible and you're being accountable. So that's why I will accept the lowest amount. Please have it paid today. If you fail to pay, not only will a civil judgment be entered against you, but I will issue a warrant. You could sit up to 6 months. Okay?
Okay.
Thank you so
Thank
much.
you.
We are adjourned.